This meeting is being recorded.
Okay, hi, I'm Kate Floss, coming in for another video, and I've got my friend Heather come to visit me today. And Heather's been asking me some questions about the Declaration of Independence of New Zealand of 1835. There's 1834, 1835, and the times of the kings and the times of the queens and the times of the barons and all of those people that have been involved. Everything that happened in our past is having a great effect on what is happening to us in our present. So Heather's been asking me lots of questions, so I'm just going to make this short video. I'm hoping to make it around about 15 minutes. We're going to go where I'm up to with my ideas from 1820, from England to Scotland to Ireland to Australia to New Zealand, 1820, to America, to Canada, and to where we are presently in this present day of this despotic rule from all of our leaders. So we're going to start we have to start in 1688. That's where we're going to have our starting point. The 1688 that overtook the Magna Carta, it trumped the Magna Carta. The Magna Carta was written for barons and kings and popes and bishops, but the commoners were not put into it. They were all considered to be the village idiots, not permitted to own land. The next document that came after that was the 1688, it's called the 1688 Will and Mary, which has got all of our rights. Now that is a very special document because in the 1688, it said that the Parliament would be in control and the Parliament would be run by the people, that we would run it. We would vote who was going to go in there, and we would be, and it's the 1688. Why is it different from every other document that you have? Because it's the 1688 that is the only means, it tells you in there, it is the only means. See, Parliament, when they make a law, they write the law and they send the bill to you. That's why they're called bills. They write the law, they send the bill to you, all right? And then if you dispute that bill, you go to the select committee and you can dispute the bill and they will take into account what you've had to say. Anybody can do that. I've just recently done one, so you can do that. However, if the bill is then passed in Parliament, if that bill is repugnant to your 1688, and it's got many, many laws that they have to follow in there, if it's repugnant to any of them, being the main one being that foreigners are not allowed to govern over us. They're not allowed to have any authority. And this prevents any foreign nations, foreign governments, United Nations, from entering in your country and having power over you when you haven't voted them in and you haven't chosen those laws for your own country. So the only means, once a law has been made by Parliament, they own parliamentary sovereignty. And when they own parliamentary sovereignty, that law can never, ever be changed unless they change it by another act of Parliament. But you can take that law if it's repugnant, and it says in the 1688, you can take that law and you can take parliamentarians to the court and you can dispute the law that they made. If that law is overridden by a Supreme Court that it's repugnant to your 1688, then it's not the parliamentary law that trumps everything. It's the Supreme Court ruling. They will trump it. They will look at what the government's intention was, and they will look at your right as a person, as an individual, and they will decide who is correct in their right. First in time, best in right. It's not first in law, best in law. The laws can change every 5 minutes. It's first in right, best in time. That's what it says. So the 1688 is first in right for the parliamentarians. So then you can come over to New Zealand, eh?
Is the 1688 under imperial common law?
Yes. The only means for you to take parliamentarians to court is through the 1688. It's the only means. You can't take them through anything else if you want to get a law changed. So if they make laws in the lower court, but those laws have no meaning either. They're just the opinion of the judge. It's only when it goes to Supreme Court that Supreme Court and Parliament have talks together about whether a law was against our right as people or not. So that's what they're trying to prevent. Now, that came into New Zealand. Now, we want to get to now, I'll just explain this quickly to you. In 17, around about, so 1689, the 1688 was brought in 1688, 1689. In around about 1740, all that law was done under kings. It was all done under kings under a man called, in a law company in Trafalgar Square, I think, by a man called Joseph Butterworth. Joseph Butterworth did all the king's law. And all the king's law, it was under the king's law in previous to that, in 1818, his nephew called Henry Butterworth entered into the King's Law Company, and he split from the King's Law Company and he started the Queen's Law Company. He started the Queen's Law Company, Butterworth's Law again, still Butterworth's, and that was done for Queen Victoria, who had already been born but was not yet queen, but was earmarked. See, who's going to be king and queen is earmarked decades ahead of time. And they create everything decades ahead of time from when they're born. So when they're born, laws are created for them for when they get older and they come to power. So it's all done decades and decades in advance. That's what happened to the King's Law. King's Law was still an offshoot of the Pope's Law and the Magna Carta Law, so it was still coming into being. And Queen's Law, so in 1820, the Hongi Hika and several Maori chiefs went to England and studied the laws of England, and at the same time, the New Zealand Maori language was put into writing into a law, under canon law it was put under, and Jewish law actually took those two. And so then they came to New Zealand then just rudimentary, right? In 1835, under the King's Bench, a flag was given. Now there's dispute of what the flag was given. Now the flag, according to my research, was 5 points with the red St. George cross, and for it to be the red St. George cross, it had to have a white outline. So it couldn't possibly have been, and I've explained in other videos, but I'm not going to dispute the flag that you use, and that's not what I'm here today. I'm just giving the lineage of law that we have. So under that, the whakaputanga, or the declaration, was given. Now that was under the King's Bench flag. I'm not going to dispute on which flag it was. I'm only going to say I will agree King's Bench flag. And that was a business flag, a trading flag, a business flag, and nothing more. It had nothing to do with the governance of the country. It only had to do with ship trading from one part of New Zealand to another part of Australia and some other parts of New Zealand. And it was a trading flag under the King, a commercial flag, nothing more. And the Declaration of Independence says in there that they will not allow, in their collective capacity, they will not allow any laws to be brought into New Zealand or law companies then was appointed by them. That's what it says. And then on the 4th article, it said that we will send this letter thanking the King for the flag, and we will, just as he has become our parent, we will protect his subjects under the subject law of that 1688. So they understood what subjects were, and they understood that we were to be protected under that. And it was a very simple law of no cruel and unusual punishments, forfeiture of person without conviction, and allowing us to speak, and a few other things that they allowed us to have. So that's what they said. In 1837, Henry Butterworth's law, so we got two laws. We've got Joseph Butterworth's under King's Bench, and then we've got Henry Butterworth under Queen's Bench. And Queen's Bench law came to power in 1837 when Queen Victoria ascended to the throne. Next, after that, Queen's law officially came into New Zealand under Chief Tamati Wakanene and Patu Oni. The tribes, the 13 tribes, the 13 chiefs and the 34 chiefs that signed on that Declaration of Independence of 1835, they split. And they were arguing. One lot wanted the Queen to come in, and one lot wanted the Pope to come in with the missionaries. So one was Pope with Jehovah's Witness, missionaries, and one was Queen's law with the Queen. So they all had this fight. I'm not going into that today. So then, these are all the facts that you can research. Then, on the 14th of January, Queen's law came to power in both Australia and New Zealand. And that's when New Zealand became able to make laws in their own country, subordinate laws, under the protection and the guidance of the Queen's law. So that's when they were allowed to start. Then they brought in the treaty. If you read the preamble of the treaty, it only says that we're going to bring in the Queen, we're bringing in Hobson to protect the British subjects. Nothing to do with the natives, nothing to do with them. It says to protect the British natives under the subjects status, subject laws of 1688. And then it also says that they would also like the natives to concur, to think about if this what they would want to have. It only says concur. That's what it says. But it doesn't say that for us Anglo people. For us Anglo people, it says we're going to govern over the Anglo people. If they murder someone in that country, they're going to be tried under Queen's law, under the 1688 laws. So that took relief for the native people, that because they didn't know how to control the missionaries and the Anglo people. So that took that burden off of their shoulders and put it onto, gave permission for the Queen to do that within their country. So that's what gave the permission to the Queen to control the Anglo people, not to control them. So then you've got from 1841, a court was set up, a native court was set up in 1841. And then between the time of 1841 right through to 1847, shiploads of Anglo white slaves were shipped into New Zealand from the highlands of Germany, from the coldest, most terrible places in Ireland, and from the highlands of Scotland. They were all brought in. And those people, most of them they had to be younger than 30. Most of them were children as young as 10 years old that came without their parents, that were put on the ships to come and work as labourers. They were dropped off at the ports of Auckland with nowhere to live, nowhere to stay, and they were arrested for being vagabonds. Once they were arrested for being vagabonds, they were put on the road gangs to build the roads and the railways of New Zealand. And they were lucky they got 3 meals a day, and they were supposedly cared for. Because this was the Maoris' problem, that they didn't have infrastructure. They had no railways, they had no roads, they had no courts, they had no nothing, and they were not able to do it. So this is how they asked to bring in the white slaves. The condition for bringing in the white slave immigrants was that they would be protected under the Queen's law. Nothing to do with the Maori. They would be protected under the Queen's law, and so therefore they were allowed to be slaves brought to New Zealand as immigrants. Now, they got direct covenants with Queen Victoria, which I'm the owner of one of those. There are people that are the owners of these documents that have a direct covenant, nothing to do with New Zealand government, nothing to do with Jacinda, nothing to do with the Maori. We've got direct covenants given to us with Queen Victoria that we and that they and all their descendants would be protected under their subject status. Now, all these, and Tamati Wakanene also went and got one of these covenants with Queen Victoria and made himself a subject under the Queen's law. And he became a worker of the government. He was basically the Governor General for the Maori. Hobson was the Governor General for the Anglo people and nothing to do with Maori. And Tamati Wakanene was the Governor General for the Maori and nothing to do with anybody else. But he was bound to Queen's 1688 law that he had to follow in order to govern the people and set everything up. So that's how they did it, with two legs. There were two legs, and both of them stood alone. The pillars of the temple stand apart, and yet they stand together to hold up the roof, and that's what we were. Pillars of the temple standing apart, holding up the roof together. So now, all of that was done under the King's Bench flag, trading flag that they had sent to New Zealand. So it was all done under there. It was still done under that flag. Now, what you all don't know is a man called King Augustus. King Augustus of Hanover was the owner of the United Kingdom. Queen Victoria was trying to get him out. Queen Victoria, together with Tamati Wakanene, and at this stage, America comes into the show. It was America that would set up all the trouble in 1840. America was trying to take New Zealand and the Pacific Islands. America and France together were trying to take the Pacific Islands and New Zealand. And England the chiefs were opposed to that. And so that's why they brought in England. So there's a whole big thing. Now, America threw England out, as you know, and took America. And then okay, let's get to where we are. So 1852, the Constitution come in under the King's Bench flag, trading flag. There's still no New Zealand flag, still not existing. So that was brought in the 1852, and there's only 3 articles that pertain to the New Zealand Maori. Section 71 saying they'll set up their own governance and they'll have their own courts and their own parliament and their own everything. And Section 70. And then all the rest of the 1852 Constitution is to do with our courts, our governance, and our parliament that we would have. So there we have 2 pillars still. So theirs is in Section 71, which was proclamated in 1888. Theirs didn't come into power until 1888. Ours came into power in 1852 under the Queen, but they're still not under the Queen. They're not. All Crown lands at that time, all Crown lands were forbidden to be bought or sold without going through Queen's grant. All Maori lands were forbidden to be bought or sold without going through Queen's grant, where she had lawyers checking everything for them so that they weren't getting cheated anymore. So she had her own lawyers from England with them, and all those missionaries from way back in the beginning, they're teamed up with America. So they're teamed up with America and the Pope and France. And then Hobson and those lawyers that she appointed to work with New Zealand Maori under Section 72, they're all come out of England. So there's all this big thing going on in New Zealand, a huge shift, transformation of what's going on in their country. Yes, then this was done all under their direction. They were with it every step of the way. They were with it. And then, so that's 1852. Then 1860, they have a huge Kumarama Conference. Every single chief came to the Kumarama Conference. They all gave their decision if they wanted their governance to go under the Queen or not. 1865, they brought in the Queen's law into New Zealand under the Native Rights Act. Now that there was when they closed the Native Land Court was closed, and they all went under Queen's law. Queen's law being the 1688, that's it. They were told in the 1852 that they could make any laws that they want to, as long as it's not repugnant to the 1688. And that's what Parliament does. They make subordinate laws, but the minute that it's repugnant, 1688 gives us permission to take them to the court and stop them. So that was all done under the King's Bench flag, with King's Bench law and Queen's Bench law, both of them. In 1888, Sydney Taifanga, I think it's Taifanga, he created the Constitution for the New Zealand Maori. So he created that in 1888, which they have hidden from us. It's there, and it's hidden from us. So that stood along the 1852 and the 1888 of the Maori. 1852 is the Anglo, 1888 is of the Maori. But we joined together in section 71, 72, 73. That's where we joined together. And then we both had our own pillars of governance. And in 1908, they set up the Judicature Act, where all Supreme Court came under the rulings of the Judicature Act. They also set up the 1908 Declaratory Judgment Act. The 1908 Declaratory Judgment Act gives us permission under Section 3 that any law, any article, any memorandum, any act, anything that comes out of Parliament, if we want to question a point of that, we are permitted through the 1688, which says the only means to take government to court is through this, we are permitted to take them to court by that together. And then that whether you're Maori or whether you're whoever you are, you're permitted to. 1901, Queen Victoria Tamati Wakanene Patuoni, who had been together with Henry Butterworth Company right through from 1818, they have been together right through until 1900, when they managed to throw America and King Augustus's son out. He was the owner of the UK and they got him out, and it all went under the Queen and us through that. So they got him out, gone. And it's at that time that the New Zealand flag came in 1901, 1902, the Union Jack came in. So all these laws, all of them were created under that King's Bench flag. That is a fact, to my knowledge. Everyone out there, I'm not a lawyer. This is just what I have pieced together in my own way to try and make sense of what they're doing. Any lawyer can come in and dispute everything I say, because I am not a lawyer and I don't know. This is Kate Floss's legal world. This is in the world of Kate Floss's law and nothing more. So that's how I pieced it together, based on the information that everybody's been throwing at me. So I've tried to create a timeline, a lineage of what our main documents are. So I don't work in subordinate laws. In 1968, a company called Nexis bought out the King's Bench Law Company and the Queen's Bench Law Company, and they bought out also every media outlet in the English-speaking world. They bought the whole lot So there, Lexis means law and information systems, and Nexis means media and information systems. They own the copyright to everything. And that's why you've got the Parliament paying the media organisations, because it's all paid through Nexis. And Nexis was brought to power in New Zealand in 2020. But all laws you see now have got Nexis on the bottom of them. And they get the royalties for every single law that you make. Every single time that you quote them, they get a royalty. Every single time that you use them, they get a royalty, because they own the whole shebangle. Every time a media outlet wants to write a story and they want to cover a story, they have to get permission from Nexis. Every time you want to use a law, you have to get permission from Lexis.
How were they able to buy them out?
I really don't know. I'm in my infancy. This is just what I know.
And who are they? Are they American? Are they? Who are they?
Yeah, they're in America. They're based in America. Wait, because I'm going to get to you I'm going to get up to you in a minute. So I'm almost there, but I'm not there. So wait till I get up to you. Then I'll open for questions. So 1968, but they must have been planning all this for many decades. So they only came to show themselves in the light in 1968. In 1972, they entered New Zealand. And in 1972, the Maori Queen went and signed documents with the Pope. I don't know what she signed. In 1974, so 1972, LexisNexis bought out all of the companies. 1972, the Maori Queen, who was backed by the Catholic Church. She was backed by the Catholics, and Dame Fina Cooper, who was raised by Catholics, Claudia Orange and her father, and all of those. She went to meet with the Pope. And another man that went to meet with the Pope was Manuka Hanari. Manuka Hanari rewrote the Whakaputanga in a new version, in a new English version. And in that, he removed the collective chiefs and he put in the true rulers, and he removed certain pieces from it. That's never been challenged in a court of law. And in 1974, Manuka Hanari also went to visit the Pope. And I don't know what documents that they signed. Then he came back to New Zealand in let me get my dates. 1976, Muldoon. 1976, Prime Minister Muldoon came to power, and a case was sent to the court using the 1688 against him. Prime Minister Muldoon brought forward all of the Queen's law and put it in the cabinet manual. He brought it all forward and instituted it into New Zealand again, which brought all those laws that I've just told you about, all got reinstituted into New Zealand under the Union Jack flag. So he grabbed it. He must have known what was happening with LexisNexis, and he grabbed it and he put it in before they could throw him out. And his signature sits on the cabinet manual today. You can go and look at it. And that's got all the imperial acts and the treaty and everything in it, due to Prime Minister Muldoon did that. So I'm still not sure in what I'm going or where I'm going. Anyway, in that law, the case was won by Fitzgerald, and it said that any laws created previously, a new Prime Minister coming in can't remove them if they still apply to the people that are living at that time. So they can't remove them for us. That's why they've imported 2.5 million refugees and immigrants, because they can't remove them from us, but they can give them a new set of laws. Now, I've only just discovered, and I've lost my bit of paper that says this. Here it is. So okay, so get that, you've got all those, you've got your Declaration of Independence. You'll have to sit down because I've got to talk. Don't disturb me. I've got to remember a lot of stuff here. You're disturbing me. You've got your Declaration of Independence, you've got your treaty, you've got your 1852, you've got your Kumarama Conference, you've got your German Settlers Act 1844, you've got your 1865 Native Rights, you've got your 1908 Judicature Act that sets up the Supreme Courts of New Zealand, you've got your 1908 Declaratory Judgment, and you've got your 1888 Constitution of the New Zealand Maori, and all of that allows for us to have power over our government. So that all comes from that. Then you've got your 1972, Maori Queen goes to meet the Pope, Manuka Hanari goes to meet the Pope. They changed the Declaration of Independence to have a new meaning, all right? And then where are we up to? It's 1976, Prime Minister Muldoon brings all those laws forward and puts them in the Cabinet Manual into New Zealand law under the Queen's flag. So that's how all that goes on. Then, so that's the connection of the King's flag and the Queen's flag coming in 1976 from Prime Minister Muldoon. Now, 1986 in February, the Queen comes to New Zealand and is forced to sign some documents. We don't know what she signed. And then in November of that year, oh, no, before we get to that, 1975, Hugh Kafaru comes along and rewrites a new version of the treaty called the Te Tiriti. It's the Te Tiriti, which he took the Maori version and gave it a new English version. Under the new English version, he removed the word subjects and he removed the word concur. He removed all of that. He called us European and he called the New Zealand Maori citizens. And he said, he basically said, you're no longer subjects, none of you, not the Anglos and not the Maori, neither of your subjects. And if you're not subjects, then you don't have subject law. So that's what he tried to do. Very deceptive. He wasn't able to do it, but that's what he's done, and nobody has challenged him in a court of law. So these are the things we need to go and challenge. Now, following, oh, my husband's going to kick me. Following on from that, so Hugh Kafaru, and then 1986, they removed the 1852 Constitution, all right? And then they brought in the, 1986, the Queen comes in February. In November, the Pope comes. For the first time in New Zealand's entire history, a Pope set foot on New Zealand soil and appointed a Catholic bishop to the soil of New Zealand through Hugh Kafaru, through Manuka Hanari, who was his tour guide for the entire trip. And that Jeffrey Palmer, back in February, Jeffrey Palmer and David Lang had stood at the airport and they waved goodbye and they said, goodbye to the Queen. That's the last we're going to see of you. Goodbye, and out with the Queen. And then the Pope comes in November. Then in December, the 1986 was removed. All right? Or it might have been the other way around. Pope came in December and the 1986, the 1852 was removed in November. It might be, it's one of those two. So that's all what's going on there. Moving forward, 1990, they bring in the 1990 Bill of Rights. And the 1990 Bill of Rights was inserted into the Cabinet Manual. The 1990 Bill of Rights doesn't give us any right to take our parliamentarians to the court. The 1990 Bill of Rights gives us some rights for, it's a workers' right, it's an ordinary law, not constitutional, and it gives workers the right to prosecute the government, and the outcome is that they can go to the United Nations and make a complaint at the United Nations. Whereas our 1688 takes us directly to Supreme Court and allows the Supreme Court to change laws over Parliament when they're repugnant to us, to our right. But the 1990 only gives us the right to go to the court and then get the court ruling and take that court ruling to the United Nations. and the New Zealand Parliament can override the court ruling, whereas they can't on the 1688. If you get a Supreme Court ruling on the 1688, the Parliament must stand down on that law. If you get a Supreme Court ruling on the 1990, due to the justified limitations, the Parliament can stand down on that law or not. If Parliament decides to not stand down on that law, then the person can take it to the United Nations. So that's the difference between the two laws. They're not the same. Now, in 2003, so 1993, they attached, through Section 19, they attached the Human Rights Act to the 1990. Human Rights Act, Section 5, subsection 2, KII, says that they will work with the Prime Minister to make all New Zealand bound to any international instrument of law. So that would include an American instrument under Lexis Nexis, a United Nations instrument under the WEF and all of those, any international instrument, and you will have no say, none whatsoever. That is in the Human Rights Act of 1993, Section 5, subsection 2, KII. That is the case that I have taken to the court. Section 28 of the 1990 Bill of Rights says that other rights that were created before 1990 for us are not included in this law, and they still stand. So that's talking about the 1688 that still stands, right? 2000, it's going to get a bit complicated, but you can watch the video later. 2003, in 2003, or around that time, maybe 1992, they set up a committee to remove the 1908 declaratory judgment that allows us to go to the court, and to remove the 1908 Judicature Act that set up the Supreme Court. They abandoned it at some point because they weren't able to do it. So they had to rewrite a whole new legislation which came to power in 2021, which is called Secondary Legislation of New Zealand, because they were not able to do it under all those legislations previously. Because of Muldoon, they weren't able to remove any of it. So they came up with a new thing to create secondary legislation. All right. So the Supreme Court allowed them to, when they created this in 2003, so they had the 1908 Supreme Court Judicature Act, and then in order to create this secondary legislation, they couldn't remove the 1908 Judicature Act, but they were able to create the 2003 Judicature Act, which included the 1908. And then they set up various laws within there, and then they closed the 2003 Judicature Act and brought it all forward. They brought the 2003 Judicature Act forward to the 2016 High Court rules, which did not have the 1908. It had different laws for the 1908. It made a new law for the 1908 declaratory judgment, which allowed us to take Parliament to court. And you'll have to go back and study this, and then if you study it, you'll know what I'm talking about. Then they made a law through the 1990 and the Human Rights Act and through the Judicature and all of that. They made a law that if you wanted to go to the court, you had to be part of an organisation that the government approved of. They only approved of a couple of organisations, which was the Otago Law, the Tikanga Law Society, and various other ones like that.
Who are all
And
on
if
their
you do-
payroll.
Yeah.
So
In order for them to go to the court, they have to use the 1990 Bill of Rights, and they have to use the Human Rights Act and not our 1688. So if you contact them, they will not take your case, which is what I'm fighting now in the court.
so they want you to go through the UN, pretty much, who has caused all this trouble in the first place.
They only allow you to go to the UN. They do not allow you to go to Supreme Court and get a ruling on your 1688, but they allow you to go to the UN. And then that you said, when we were looking at that, what we now have in our, so under that, if you know your Declaratory Judgment Act 1908, Section 3, it says any one person who has only a question about the construction of any regulation, any bylaw, any legislative instruments, you only have to have a question, you're permitted to go to the court. They brought it through and attached it to the Treaty of Waitangi, and under the Treaty of Waitangi, they put the Treaty of Waitangi into the secondary legislation. And under the secondary legislation, they removed regulation, bylaws, other legislative instruments from the 1908 Declaratory Judgment Act. They removed those words and changed the words to be, under the treaty, changed the words to be anyone that has a question of the secondary legislation. And the secondary legislation is the 1990, not the first legislation of all our laws that we've got from the past. So this is how they've got around it, but they were not able to remove all of those laws, but they were able to put a law in place of all those laws and then create two laws to prevent us from getting access to the old laws. Actually, they created three laws. The first law was the Manic law. They said that you cannot enter the court against the corporation of Lexis, Nexis, in the secondary legislation without a solicitor. All right? No solicitor will take any cases in regards to the first legislation because they're supported by the government. So they will only take a case in regards to secondary legislation. That's the first one. Second one they said is that, what's the first one? The second one they said is that you need to have a group. You can't go to the court unless you have a substantial public group to go to the court. Whereas under 1688 and 1908 declaratory, you can go as only one person with no solicitor and you can go for free. Under these legislation, secondary legislation, you need a solicitor, and not only do you need a solicitor, you must have a group, and the group has to be of an approved organisation. And when I went to those groups, Otago Law Society, they only take you if you're an immigrant or you're in workers' rights or if you're a Maori. That's the criteria. Immigrant, workers' rights, and if you're a Maori, you can go. Then they said to me to go to the citizens' advice, and they provide lawyers for you if you haven't got a lawyer. Same thing. You've got to be a Maori or you've got to be an immigrant. And they have classes for immigrants 3 times a week. And if you're a Maori, you can call them and they'll give you a lawyer straight away and take you right through the court free. If you go to the Otago Law Society, they have a free lawyer in a Zoom every single night from 5 o'clock to 7 o'clock. You can enter into their Zoom as long as you're an immigrant or a Maori. Yeah. And if you want to go there on constitutional law, they will not allow you to enter because the government does not provide for them in constitutional law, only provides for them in the human rights law, which says human rights law that says that we will be bound to any international instrument, which is a very dangerous law to have on your shoulders. They could say, we're going to chop your heads off. You have to let them, which will bring us to, they then changed our language. The official language of New Zealand used to be English. They changed the official language of New Zealand to be New Zealand Te Reo Maori, right? And then they had a man from an Urdu Muslim sect who was thrown out of Pakistan, and he set up shop in England, and he's been working in England to bring down the Commonwealth in England. And he is some kind of not a Sikh, but he's an Urdu Muslim, and they were thrown out of Pakistan. He turned up in New Zealand in 20 years ago. An Urdu Muslim sat in South Africa and wrote the Quran into the Maori language with a group of Maori in Africa. He did it outside of New Zealand. He would not have been permitted to do it in New Zealand because it would have been illegal for him to do it. They did it outside of New Zealand in around about 2020, or maybe a little bit before that. The Maori king, King Tui Huiteia, he had a Muslim Islamic ceremony on his marae where he signs seals with the king's seal. He had an Islamic ceremony accepting the Quran in Maori language, and the Maori language is now the official language of New Zealand. So you're all under Islamic law, even though you don't know it, because of that.
Wow.
Yes, so you're all under Islamic law now as we speak, in my opinion, because of the language. The official language of the country is Te Reo. The New Zealand Maori king has teamed up with the King of Tonga and with the Mātai chiefs of Samoa and with the Cook Islands chiefs. They've teamed together, and they have had the New Zealand Maori accept. Now, the King James Bible is not in New Zealand Maori. King James Bible is in English because it matches the 1688 under the King's Bench and the Queen's Bench. It's all done under that because the New Zealand Maori went to the courts and made English their language. They did that under King's Bench and Queen's Bench law. In the 1975, they collected 30,000 people together and sent them to the court to make New Zealand Maori the official language of New Zealand. And then they gave the Urdu, went to the, I'll put the names up there, it's on my Maori pens, but I haven't got it right now, not off the top of my head. So, so this is where you're all headed. Now, you just recently sent me a document. I'm going to end my video because I've got to go. And I'll have a few minutes for questions. You recently sent me a document, so I'm trying to get into the court, and they have blocked me over the 3 reasons: the solicitor, and then they've blocked me over the group, that you don't have a group, you don't have a solicitor. Under Manic, you don't have a group. Under the secondary legislation, and then they've sent me, I went to the appeals court, and I've challenged those laws in the appeal courts, and they've laid on me thousands and thousands of dollars of fees to take it through to Supreme Court to get the law looked at. But under the 1688, it says we have the right to petition the king, and all fees for doing that are illegal. All commitments and prosecutions for doing that are illegal. So that is what I've gone to Supreme Court now as we speak to fight. Now, that all happened during this month of August. And then all the NEMA laws were not completed in New Zealand which is the National Emergency Management Act. And then, so all what I'm doing on the 9th of August that you just sent me, Heather, the 9th of August, there's been complaints that the judges have not been making firm decision due to the confusion of the first legislation and the secondary legislation, the Lexis, Nexis, King's Bench, Queen's Bench, the treaty, all of this is all tied up into there. That's what I'm in the courts. And then on the 9th of August, New Zealand signed up over in America under the guidance of Lexis Nexis, no less, signed up with FEMA, who has tied us all up into the United Nations through FEMA, NEMA, and all of that. Now, I'm going to make one just last point that I was going to make. America and Canada wrote laws in way back in the 1970s and in the 2000s. Actually, after 2016, both America and Canada and several other Commonwealth countries bailed out of the United Nations. They bailed out of the United Nations and they wrote themselves constitutions for their native people, detaching their native people from the United Nations. They wrote their own bills of rights for their own native people, and they said, our native people will use United Nations laws if they want to or if they don't want to. And then they will be under the watch of our government for what they agree to and what they don't. Canada and America wrote themselves those protections, and they left the UK of the Commonwealth, Australia and New Zealand, they left all of us naked in the jungle with no protections and threw us under the bus of the United Nations under Human Rights Act Section 5, subsection 2, KII, that New Zealand will be bound to any international instrument, which includes FEMA, Lexis, the whole lot. So they're putting us into, they're pushing us all into the pen, and they're locking the gate. And so that's all I've got to say about all that. That should be the end of my video. It's about 20 minutes. And so that's, have you got any questions? Because I've got a few minutes for questions for you. So that's where we are today.
So can we unlock the gate and get the hell out of there? How do we get out of that getting under FEMA? Because that's only recent, and that's only because we're under a state of emergency, but that's how cunning they are. So we pretty much have to take them to court to say that's illegally done?
My case is already in the court, and it's already at Supreme Court level, and it can include NEMA in it, because I've got the document where that the courts, the New Zealand Law Society did the document where they said that the courts are falling short in their decisions, and they said it's because of the NEMA and all that's tied up. So I can tie it all into my court case. Where my problem lay is that I'm a sole person doing it on my own with my Oreo group. I've got an Oreo group. None of us have got we've got high school education. We finished high school in Form 4 or Form 5 or 6. That's the limit of our education. So we've only got this through all the groups that have been doing this and everything, and then we've just mapped it all, that other people, this group's doing this group's doing this group, and we've mapped it all to put it together into one inclusive box. We put it all into one box to sort through, and we don't know what we're doing, but we have been searching, not per se that we need a lawyer, but just one that would come in and talk to us, even if they gave us an hour to. I'm at Supreme and I don't even know what document. It takes us 3 days to figure out, to find one document to fill in to give to the court. That's how long it takes us. If we had someone that we can call up and I could say, hey, I need to file this document. What's the document? Can you send it to me? It would save us 3 days of work. So, and then they could say, hey, you can't do that. But we've got a lot of people that have been advising us, but none of them have been lawyers. And of course, we're not lawyers. So we've been to the Otago Law Society. We've been to the Victoria University. We've been to the Citizens Advice. We've been everywhere. The only person that has come forward that did help us, and I will say it, and I'm not ashamed to say it, and people can rave on all they like. The only person that came forward with no strings out of the just feeling sorry for us, I think, was Liz Lambert. Liz Lambert came forward and she said, I can't be involved with your case because I'm very busy, but she said, I'll give you an hour of my time, and if you've got any questions, you can ask me. And she came with a bunch of things that might be helpful. She said, and we used every single thing that she brought to us, we used. And she came forward out of just the kindness of her heart, a very, very wonderful thing. My husband's going to be calling me. I'm in so much trouble. So any last questions that you want to make here?
No, I'll let you go. You go.
Right, Kate Floss and Heather signing out. We're both keeping an eye on us. None of us are making any decisions, but this is for the Oreo team. We're in the Supreme Court, and we just wanted to make a quick video to let you all know. You can all go and research these documents yourself. If you're avidly involved with all of this, go and search. If you're too bothered and you're going to be calling us and saying, where do I find this and where do I find that? You're not worth our time, because we're not out for individual case. We're trying to help New Zealand as a country and the future generations of New Zealand. We're not after helping people in their individual cases for whatever their grievances are. They've got a black eye or the police beat them up. We're not doing that. We're in the courts trying to figure out what's going on in Parliament, what's going on in the courts. That's where we do. LAW law. That's where we are. LAW law.
Just trying to save the country.
Yeah, so if anybody wants to be involved, you've got to work hard. You have got to work hard every single day. Watch the video, pause the video, Google the document that I've said. Watch the video, pause the video, Google the document that I've said. Go through it, do your homework, and then come on board with the Oreo team. And
yeah, but I've noticed Google has changed documents. You know, I've read one document, 3 years ago, and I've read it again, and the things that I read 3 years ago aren't in there anymore.
Well, the Judicature Act, a Supreme Court Act, the entire court system of our country is in the Judicature Act. And in 2003, they created a whole new law and brought it into there. And then in 2004, I think it was, or maybe a bit later, they repealed an entire Judicature Act. The entire thing was repealed. And then they said, use 2004. And then they said, don't use 2004, use 2006. Well, I don't even know. When I asked the Supreme Court which law that I should go to get my documents to file, they couldn't even answer me. They said, first of all, they said 2003. They were on Google like me. Then they said, oh, no, not that one. That one's finished. Go to 2004. Then, oh, no, not that one. Go to, and then even they didn't know which one to send me. This is how bad it is. This is the mess that they've created. They've got a first legislature, and then they've got a second legislature that is completely repugnant to all the first legislature, and nobody knows what to do. The judges don't know what to do. The lawyers don't know what to do. The Parliament doesn't know what to do. Nobody knows.
And who is all this chaos driven under? The UN and FEMA. So that's pretty much the people.
Yeah, I think, well, Nexis, the people behind Lexis Nexis are behind it all. So whoever's,
who's that?
you've got to find out who's behind all that, and then that's where you'll know. But I'm not that far. This is where I'm up to. This is only just where I'm up to. Okay, I better go. See you
Yeah.
later. Bye, everybody. Smile for the camera. Hang on. I've got to stop recording. Hang on.